everyone. For those few of you who don't know me at this point, I'm Andrew Cohen. I'm the director of the Rainbow Center here at the University of Arizona. Let me welcome you again a little bit more formally than I did this morning to our 5th annual National Conference of Constitutional Law Scholars. This is our first year back in person after 2 years online and a COVID hiatus year. It is wonderful to see so many of you here in person. Many of you, of course, have been with us in prior years, as our keynote speaker today has been. This event is sponsored by the Rainbow Center for the Constitutional Structures of Government here at the University of Arizona's James E. Rogers College of Law, and is co-organized with my Arizona colleague, Eunice Lee, who is here today, and Shalera Roisman was not able to be with us today. As well as Rebecca Aviel up here in the front row from the University of Denver's Sturm College of Law. I am delighted to introduce to you our 2023 keynote speaker, Aziz Huq. Aziz is the Frank and Bernice J. Greenberg Professor at the University of Chicago Law School. He teaches and writes on domestic and comparative constitutional law among a wide range of other subjects. If I tried to summarize his body of work, I think we would be here past dark, but I commend to you his terrific recent books on the collapse of constitutional remedies and how to save a constitutional democracy. Today, Aziz is going to talk to us about the rule of law in American constitutionalism. He will speak for roughly 30 minutes, followed by Q&A, and I will keep the cue. Please join me in welcoming Aziz.
Thank you so much, Andrew, for that very kind introduction. And thank you to Eunice, Shala, and Rebecca for including me in the program. I'm really honored and thrilled to have this opportunity. It's an honor in particular because I'm acutely aware of the large shoes I've got to fill, given the previous speakers who served as keynotes to this conference. And I'm very aware of how much of a challenge it is to give this presentation, not just because, as Ilan Lerman just told me, I'm apparently competing with the hot tub, and also basketball, but also because we obviously are at a moment in the discourse of constitutional law where both public and scholarly debates are more polarized, less anchored in shared beliefs or methods than at any time in our recent memory. So, given that context, my initial impulse was to try and find a point, a starting point of common ground in these remarks. And being an efficiency-minded Chicagoan, I thought I could do that. I thought I could find my Archimedean point, and at the same time, expedite the labor of preparing remarks. So I thought I would do what every high schooler and undergraduate in the United States is doing, and ask ChatGPT. So I did do this. I asked the app to write an essay for me on the question of what is American constitutional law. The response I got in full was, something went wrong. Please contact our help center at help.openai.com if this issue persists. I think the lesson is that we don't have anything to fear for our jobs from the machine. But what in fact did go wrong? I want to start by teeing up that question with some events from the morning of January the 6th, 2021. The graduate of the law school where I teach is giving a speech on that morning in Washington, D.C. to an agitated and angry crowd. Wearing his trademark Stetson and quivering in the brisk January breeze, John Charles Eastman makes the legal case for denying certification of the 2020 presidential election. the gist of that legal case is captured in one of the headline claims proffered in the brief that Eastman filed just a few weeks before in the United States Supreme Court. State election commissions, that brief said, fail to follow the rule of law and thereby put our nation's belief in elected self-government at risk. Now, Eastman's bold claim is, I think, easy for many of us to mock, but we shouldn't. We should instead recall recent developments in Budapest, in Jerusalem, in New Delhi, even today, in Caracas. Time and again, legislation, constitutions, and courts have been successfully weaponized to disable self-rule and to do far worse. The rule of law, understood as a condition in which law guides and shapes political actions, seems, at least today, compatible with a collapse in democratic self-rule. These comparative experiences suggest that it would be a mistake to write off the flagrantly false allegations in the Eastman brief as merely aberrational. These comparative experiences would further suggest that it would be a mistake to believe that the tensions between legality and democracy were exhausted by bad faith political action. Rather, I want to insist as a starting point that Professor Eastman's comment poses a serious challenge concerning the relationship of the rule of law in the constitutional domain and democracy as a going concern. And so in my remarks today, what I want to do is to take that challenge seriously. I take it that Eastman's words pose, roughly, the following questions. What does it mean to abide by the rule of law? What good does that do? And how do we address the risk that legality can be weaponized against democratic self-government? Now, I'm not going to try and give you definitive answers to those questions. That would be far beyond the purview of a single set of remarks. Rather, what I would like to do is to explore with you some of those questions by thinking historically about what the rule of law means. That very brief dip into intellectual history, I hope, further casts some modest light on how best we, as a community of constitutional scholars, acquit our own ethical and professional responsibilities. So go back then to Eastman's words. What does following the rule of law mean? I think it's a harder question than it first looks. For many of us, for obvious reasons, that phrase brings to mind the dictum of Chief Justice John Marshall in Marbury v. Madison concerning the distinction between a government of laws, I quote, and of men. Of course, as everyone in this room knows, Marshall drew that distinction. He marked it out by the question whether there was a remedy for the, quote, violation of a vested legal right. On this view, the rule of law is synonymous with the availability of ex post judicial oversight. But now turn to the US reports today, and you will discover a rather different version of the rule of law. In the past year, that phrase has been used in 3 separate legal opinions issued by the court. In 2 of those legal opinions, the phrase rule of law was invoked as a justification for limiting, for extinguishing remedies, in particular post-conviction habeas remedies. And of course, as almost I think everyone in this room knows, the third opinion citing the rule of law was the Dobbs majority, which invoked that concept as a reason to abrogate a different constitutional right. I should confess here, and I think this is a personal remark rather than a remark consistent with the balance of my comments, that the Dobbs rule of law invocation seems to me to show how concepts of legality can be invoked to deny the existence, to suppress the existence of legitimate differences of legal opinion, to obfuscate contentious and profoundly flawed moral judgments cloaked in history, and to inflict harm on politically disadvantaged groups. Those are, I want to clearly concede, personal and contentious opinions. And even if you reject those views, I nonetheless think that a review of the case law suggests the need for a richer, more complex, and more universally attractive account of the rule of law. So what does history teach us on that score? Well, over time, there have been many different ways of speaking of the moral implications of law and legality. Think back to Aristotle's discussion in the Politics of what he called Cala Grammatica. Think of the natural law tradition that we now associate primarily with St. Thomas Aquinas. Talk of the rule of law is just one of these distinctive lexical traditions, one of several, all of which engage with the question of what normative weight law is entitled to. The origin, however, of the rule of law tradition, that particular lexical formulation, can be pinned down with some precision. It is today 138 years old. It was first used as a phrase by the late Victorian Oxford Don, Alfred Venn Dicey, in his magisterial book, Introduction to the Study of the Law of the Constitution. Note well, for Dicey, the rule of law was one of two abiding pillars of the English Constitution. It was a concept of local operation and not general, let alone universal, application. But the term proved too rich to be bounded in this parochial fashion. And in the 20th century, Dicey's terminology was taken up by figures as diverse as the Austrian economist Friedrich Hayek, working at the London School of Economics, the analytic philosopher Joseph Raz, working in Oxford and in Columbia, the English jurist Tom Bingham, who would sit in the House of Lords as a law lord, and even such figures as the World Bank president, James Wolfensohn, who led that organization in the 1990s, and Chinese Premier Xi Jinping. The recent years, for example, have seen not just the publication of Xi Jinping thought on the rule of law, but a 5-year plan for achieving a rule of law with socialist characteristics by 2025. So has the rule of law gone the way of the Macarena? Bubble tea, a local delicacy that's gone global and thereby lost anything distinctive? Is there anything left by way of an authentic call? I want to concede that the observed usages of the phrase rule of law are extremely diverse, and there is an important sense in which certain recent usages are strategic deployments in ways that seem to invert the central historical polarity of the idea's values. But I also want to resist indeterminacy or nihilism with respect to the rule of law. Having spent a number of months now reading historical texts in the rule of law tradition, I want to suggest that we can pick out two common threads to the rule of law that even bad faith usages trade upon. I call these the guidance function of law and the reality of institutional bite. As we shall see, they are complementary. They can be used, I think, to help us think more clearly about Professor Eastman's questions. So what do these two concepts entail? The first thought is that law must be capable of guiding those it purports to bind. As Lon Fuller famously explained in his parable of King Rex, law fails to guide, or can fail to guide, in several quite different ways. And if it does do this, law falls short of what might be characterized as a basic existence condition. Now, interestingly, Dicey did not pick this idea of guidance out, but his account of the rule of law assumes that in particular, coercive legal action will be restrained and will be predictable as a consequence of pre-existing law that guides it. At the same time, it's important to recognize, Dicey, was comfortable with the idea of an unwritten and hence imperfectly cognizable common law. Commentators, particularly Timothy Endicott in a wonderful article, have richly demonstrated that perfect guidance is not only inconceivable, but actually acutely undesirable. The guidance function that is at the heart of the rule of law is a public good, but it is a public good that must be traded off against other social ends. So the first element of the rule of law is the guidance function. And the guidance function turns primarily upon the verbal content of the law, the words. The second element of the rule of law tradition, however, looks to the reality of institutions. It looks to the range of on-the-ground agents who enforce the law. Dicey, like Chief Justice Marshall, asked not about what the law said, but how it worked, especially how it worked against officials and those who wield coercive state power. Dicey insisted that penalties be imposed on private individuals only, and I quote, in the ordinary legal manner, before the ordinary courts of the land. Official power, he said, must answer to the ordinary law of the realm in, once again, ordinary tribunals. It follows that a legal regime which lacks remedies systematically with respect to the use or abuse of official power is not a rule of law state, as that term has historically been understood. Note well here, however, that Dicey, like Marshall, didn't say exactly how the law would be enforced on the ground against officials. He invokes the idea of ordinary courts. But what is an ordinary court? What makes it distinctive and thereby efficacious with respect to the project of constraining official power? Dicey doesn't tell us. He doesn't say anything about the institutional qualities or the broader legal culture that is necessary for law to bite as an institutional reality on the ground. He gives us a label, not a classification criteria. Yet, despite these limits, the guidance function and the reality of institutional bite, when you put them together, can be usefully understood as the rule of law's historic core. And with them in hand, with that core in hand, we can loop back to Professor Eastman's complaint, and we can inquire about the relationship between legality, democracy, and constitutionalism in the United States. I'll offer three conclusions from that. First, the rule of law has only a weak and contingent connection to democracy. Second, the American constitutional law tradition as currently practiced is hard to square with core rule of law principles. And third, the reasons for the gap between constitutionalism and legality are hardwired. They lie deep buried in institutional choices that are functionally irrevocable, and macroeconomic and political currents that cannot be stoppered or staunched. Legality, constitutionalism, and democracy. Professor Eastman, like many of us, implied that those form a harmonious bundle, that they are at best awkward and fractious bedfellows. Let me unpack those 3 points. First, the rule of law has only a limited and qualified relation to democracy. The guidance function, for example, is in quite obvious tension with the capacity and right of democratic legislatures to change the law periodically. It also sits uneasily alongside democratic delegations of general authority to bureaucratic actors to solve complex, fast-evolving social challenges. The recent so-called major questions doctrine, for example, might better appeal to legality rather than to values of democracy that in practice it ill serves. It is true that constraints upon official discretion can and do facilitate the operation of elections that in most jurisdictions lie at the heart of the democratic practice. But it is also the case that a strict insistence on legality, particularly in the face of unexpected circumstances, can be a means to disenfranchise. Legality can undermine the fairness of elections. I was involved in helping to register people to vote in Wisconsin in April of 2020, when the pandemic was just beginning, and I got to see that happen in real time. And of course, one final caveat, when a lawyer feels free to conjure up her own facts, his own facts, free of warrant in the world, in the fashion of the Eastman December 2020 brief, any ensuing insistence on legality is both facetious and dangerous. Second, it's hard to square the current practice of American constitutional law with our 2 core rule of law principles. Now, this is not to say that there is no rule of law in the United States. Quite the contrary. For better or for worse, most law in the United States is not constitutional. It's sub-constitutional in various ways. Nor is it to say that constitutional law is persistently or inevitably indeterminate. It is rather to stress the imminent, albeit asymmetric, potential for the destabilizing instrumentalization of generally drafted constitutional norms. However well that risk of instrumentalization, of politicization, has been subsumed, has been handled at earlier moments in American history, we currently stand in a conjecture in which it cannot be suppressed. So take first the guidance principle to see why this should be so. It is not novel to observe that the outcomes of politically salient cases, particularly in the US Supreme Court, are better predicted by the partisan orientation and affiliation of the bench than by substantive theories of law. Nor is it particularly new to point to the open-textured surface of our Constitution's words as porous, not just to methodological, but moral reasoning. I am afraid that I remain unconvinced by the positivist turn among my originalist friends. I've never particularly thought that a method, when applied by its adherents, to justify both the right to abortion and a right against gender discrimination on the basis of 18th and 19th century beliefs, is one that suffers inordinately from being legalistically constrained. But it's my sense from conversations with colleagues with respect to a casebook that I'm on around the country, that many scholars today feel an increasing strain in offering plausibly neutral rationales for case outcomes when all the evidence suggests that neither neutrality nor rationality is in play. Moreover, it's my sense that, again, for better or for worse, law students increasingly resist the ethical obligation to treat judges, jurists, as reasoned interlocutors, when those jurists seem to the student to be flexing raw, unreasoned political powers in ways that extinguish those students' core rights. More generally, at a moment when text and historical sources are displaced by the quality of social and political networks around the justices as the best barometer of the jurisprudence, talk of the guidance function is, well, misguided. At the same time, constitutional law today is offered only inconstantly as an institutionalized constraint on violent state power. Dicey was an heir to John Locke, and John Locke was centrally concerned with the Hobbesian problem, the problem of the all-powerful state. But our hobnailed police are, as my friend Joanna Schwartz has aptly put it in a wonderful new book, shielded from most legal checks. So without discernible irony, we can read of federal judges ardently complaining of the intolerance of law students while embracing arbitrary state violence without legal compensation or remedy. So much for the second of the two elements of the rule of law. Third, it's hard to see how the rule of law today can once more be secured, given the way the verbal formulation of our Constitution and the path-dependent but now entrenched institutional choices that we have made as a nation about how we go about producing legality. An indication of this is that even our most doubtiest originalists increasingly disparage the quaint idea that law ought to serve as a constraint on judges. There's a marvelous recent piece in Politico on how the rank-and-file conservative legal movement is increasingly dismissive of the value of law, of legalism as constraint. The porousness of our judicial institutions to this popular time is assured. It's assured by the structural choices that are embedded in the Constitution's Article 3. Choices that channel judicial appointments through the same partisan canal that ministers and ambassadors take. It's telling that in the fractious and fraught debate that's now unfolding in Israel about judicial independence, that the option that every side recognizes as least consistent with an independent court system, as most consistent with political control over the judiciary, is the pathway embraced by the US Constitution. It's worth emphasizing that one can imagine a state of the world in which Article 3 produces an autonomous judiciary. It's just not a state of the world that we can attain. If we have broad elite consensus and low partisan polarization, judicial appointments through partisan channels would impose no great strain on the rule of law. But these conditions no longer hold. Sharp partisan polarization precipitates legislative gridlock. Policy-making ebbs first to the executive and then to the courts, as Emily Berman described this morning. And then, indeed, that policy-making authority flows to one particular federal district court, one with quite predictable partisan colours. The appointment wars, the elevating and destructive culture war by litigation that follows is very far from Dicey's rule of law tradition. It is no less distant from Marshall's government of laws. Which brings us back to us, to the scholarly practice of constitutional law. What's our role in this? By and large, ours is a scholarly community organized around not the positivist enterprise of analysis and description of the kind that I've tried to offer here, but a normative task of evaluation. Living or originalist constitutional theory purports to offer an account of the difference between law and partisan politics. Yet the paradox that strikes me is that this very enterprise is pursued in an institutional context, the American law school, that does not escape the distorting structural forces that impinge upon the rule of law more generally. Because the law school stands firmly inside the event horizon of politics, the agenda and incentives of scholars, and I want to be very clear, including me, are soaked in consideration, inconsistent with the ambition of scholarly autonomy. To see this, reflect on how we constitutional scholars routinely trade on our affiliation with and our influence on the Supreme Court to establish prestige. Proximity to effectual political power, measured by citations or by personal networks, is the coin of the realm for us. Think too about how the academy and the bench are entwined in symbiotic relations of reciprocal legitimation. Witness, for example, the many and the prominent celebrations of professors' recent graduate success in acquiring Supreme Court clerkships. Watch the epicycles of narcissistic self-promotion and obsequious groveling by liberal law schools desperately trying to eke out their primacy against a tide of reactionary judges. Or look at the precipitous rush of so-called progressive scholars into the Biden administration's open effort to deflate progressive court reform goals. Or listen to the insistent denials of originalists of the historical and political contingency of their own jurisprudential ascendancy, marvelously mapped by my former Chicago colleague, Calvin Turvey. Or listen to originalists' own epicycles of concession and critique as they inexorably lose ground in the public culture to a more politically advantageous Christian nationalism cloaked in constitutional garb, a jurisprudential blend perfected in the early 20th century by the German jurist Carl Schmitt, now refloated on the Danube and the Potomac. Even the ordinary currency of reputation among legal scholars, our publications, turns not on the application of endogenous disciplinary standards by peers. However much I admire my 2L students, I do not think for a moment that they are capable or willing to apply criteria unrelated to their transient ideological projects. However much I would like to think that my own publication record has a positive signaling value, I am hard-pressed to explain why I would believe that to be the case. Constitutional scholarship, in sum, is symptom, not remedy, for the current travails of the rule of law. Like Professor Eastman's brief, the louder its appeals to legality, the more common they are to be, the more likely they are to be instrumental and entangled in larger artisan projects. Its institutional incentives are at odds with the ideal of an autonomous, non-external ends-directed academic inquiry, and its evaluative standards, from the publication context to the faculty hiring context, are soaked through with externally relevant ideologies. So a reason not to be too harsh at Professor Eastman is that perhaps in the end we're not that different from him. Writing in 1980 about the state of constitutional theory, my former professor, Mark Tushnet, anticipated the judgment of ChatGPT. I'm sure he'll be thrilled. Something has gone wrong, he thundered, with legal scholarship. He then proceeded to offer a caustic commentary on its intellectual marginality. It's so Tushnet. Well, that seems a bit harsh to me. And it seems to me that legal scholarship today still escapes its marginality in one of two different ways. First, it seems to me that legal scholarship escapes the margin by becoming the handmaiden to a political project. A familiar example of this is the role that the New Deal lawyers played in early 20th century American history. But I would go back to Carl Schmitt for a more pertinent example. Schmitt explicated what he called a concept of the political, resting upon the opposition between a latent people, a pre-political community, defined by its morality and its faith, and its liberal enemies. And he argued forcefully that the conflict between the community and its liberal enemies could only be resolved through ruthless, violent exercise of the sovereign's decision to cut through legality and mundanity. A similar set of claims about the right of a pre-political, religiously infused or defined community to vigorously assert its moral priority over so-called secular liberalism is today on the march. Whatever one thinks of its merits or demerits, there is no saying that it is intellectually marginal. And given the path that Schmitt's work and life took, there is also no gainsaying its likely effect on the rule of law. And I don't think that's the only route that legal scholarship can take. I do think it's possible to escape the event horizon of politics in a second way, even if I often fail to do so. I think this is done, obviously, through rigor, clarity, and an acute awareness of one's institutional and historical coordinates. So I would frame the challenge of contemporary constitutional scholarship as follows. How does one work at an acoustic separation from the ideological economy of prestige that dominates our institutions? How does one do so without producing work that's entirely detached from moral commitments? How does one engage, or how does one produce work that engages with the major intellectual questions of the early 21st century, within and beyond the law school? And how does one do so without, and how does one respond to major intellectual, how does one respond to the way in which law and legality can be instrumentalized without collapsing oneself into merely the opposite partisan position? How do you produce work, that is Gramscian in its sophisticated grasp of the present moment and its dynamics, and yet not merely the predictable diatribe of the camp-following organic intellectual? I think this kind of an academic project poses questions, at least for me, about the role I play in a law school. It poses questions about the economy of scholarly prestige, of which I am a part. And it poses questions about the kinds of publications that I ought to pursue or not. Just to give one example of that, I think it raises good reasons, or it generates good reasons, to move away from the student-edited model toward a peer-reviewed model akin to the admirable Journal of Legal Studies, or the scholarly reviews that dominate the Canadian and English legal world. If ChatGPT is right, if something has gone wrong with our scholarly practice of constitutional law, it is absolutely not beyond our ken to fix it. The concentration of talent and raw intelligence in this room, to say nothing of the broader academy, is extraordinary and humbling. Let us put it to fair-minded and truly scholarly use, advancing law as a scholarly discipline, not as a mere adjunct to political partisan projects, particularly those inimical to the rule of law. Thank you.
Questions? Yes, Rachel.
Thank you. I think it's very interesting. I just have a question on a small point, which is the suggestion about peer review towards the end. So if law professors are indeed motivated by concerns about proximity to power and careerism and so on, then how does it advance matters and have them deciding which of each other's scholarship?
I think it's a matter of comparative statics, not absolute goods. Law students have no sense of internal disciplinary standards. They have no sense at all they have no developed sense of the nature of debates that have happened in the past and the way in which new scholarship builds or does not build on it. They are, both on the left and the right, very responsive to immediate ideological currents and atmospheres. It's not that law professors stand outside of that, but at least A, they have the capacity to make reasoned judgments about what contributes to a discipline and what doesn't contribute to a discipline. And B, at least as I have encountered it in other disciplines, peer review requires reasoned judgments. It requires writing. It requires an explanation of why something is justified or why something is novel or not novel in ways that I think impose a measure of discipline. So absolutely, the move to peer review is not a panacea. But I think it would be much better than our current system of student-edited journals that produces bloated, repetitive, ideologically tendentious, and not terribly socially useful, work of the kind that we are capable of doing much better.
Is it Anya?
It is, yes, thank you. Thanks for this uplifted message.
Anya was a Bigelow Fellow while I was running the Bigelow program in Chicago, and so she knows that I only do uplifted.
That's great.
Yeah. Happy, skippy optimism.
I am wondering if the desire to create a rule of law that is autonomous and non-political is part of the problem. If the idea that the rule of law can only be successful when it's really truly removed from political motivation is in a sense what makes it so very malleable and unreachable. And if there might be a benefit in admitting more of the political vagaries that go into the construction of law, inevitably, including the fact that legal decisions themselves contribute to our ideologies about the distinction between law and politics.
Yeah.
If that might, if kind of enabling that kind of discourse might make the rule of law idea less brittle, more adaptable, if also less perfect, but perhaps more attainable.
Yeah, so I'm in agreement with that. So I tried to stress in my remarks the way that the rule of law is one good among many, and that at moments it imposes costs to other goods, particularly democracy. And that tension was something that I wanted to bring out in particular, given the moment we're at, I think the moment we're still at, with respect to risks of democratic backsliding. I think that it's not just that the relationship between the practice of legality and the practice of democracy is complex, it's that the social and institutional predicates of legality are themselves inordinately complex. So the solution that Dicey has to that complexity is essentially to endogenize it to history, to say that we just do have this set of legalism-enabling institution, ordinary court, and we just do have something called an ancient constitution which embodies our eminent English liberties, right? So his solution is to place it beyond politics. But that's not a persuasive solution, right? And probably a more persuasive solution is Joseph Raz's argument, which is to say, look, legality understood as a measure of guidance and predictability with respect to the content of laws, and legality understood as a measure of constraint upon official action are imminent qualities that might surface if and only if you're lucky enough to have the right cluster of institutions and, Raz, I think, rightly points out, the right broader public culture of legality. And of course, both of those institutions, and in particular that culture of legality, right, are political outcomes. They're not inputs. And the question of how those are maintained under conditions of rampant misinformation, partisan polarization, environmental catastrophe, I mean, take your pick, it pressures upon the institutional infrastructure of a decent society. I didn't purport to answer that question.
Peter.
This is probably annoying, but I'm asking another question about the least important thing you said, which is who publishes our so you
if I had to put money on like the line in that thing, it was not the my publication record is worth shit. Like that was all taken in good because it was like, what happened my law review article? All those days I spent staring at my email waiting for this class to get. So I totally sympathize. It's been there too. But go ahead.
This is responsive to that too. So you gave a comparative answer to Rachel's suggestion. So here's another suggestion, and I'd be curious to hear your comparative evaluation of it, which is Brian Fry is publicly committed to simply, he writes an article and then he posts on Twitter and he takes the first law review author that comes, and that seems kind of good because it severs the publication placement from the signaling mechanism, which I think is something we think is good.
Yeah.
It preserves, I think, the thing that tools are good at, which is like checking all citation. Maybe it's annoying that they check them so thoroughly, but we do have.
Do you really think that the citation check says any useful function? Does it improve the quality of an article that it was citation checked?
I don't know.
I'm not sure that that's true.
Okay, so that's good. That's not a plus in your comparative.
No.
Calculus. But another thing that might be a plus is there are a lot of law reviews, and compared to other peer review disciplines, our scholarship goes out and it goes out quickly, and then we actually get to do like peer review in kind of the broad sense, which is like you get to read the thing in its final form in a published, site check whether you care about that form, and then we decide what's good and not, and if we center that in the signaling mechanism. And then the fourth, maybe third, fourth thing that's good is like, you could do it tomorrow, right? You don't have to wait for a whole bunch of peer review journals. You could just do what Brian did. We could all do what Brian did.
Well, I would say, Dave, why even take his step? Why not just post things to SSRN?
Yeah, so you don't think
why do we need a system of academic publication when we have SSRN? And how would a world in which people read work off SSRN be different from a world in which they read work in law reviews? Yes, maybe there would be a handful of pieces that obtain attention because they happen to be placed well in law reviews. But I think that any gain from that elevation function is offset by the fact that the fact of, as everybody in this room knows, writing for a 2L editor audience generates a certain kind of toxic prolixity that is inconsistent with real thought. So get rid of that, and I think you have a body of legal scholarship that's much more capable of making contributions, and much more capable of being read, right?
Let's say you're in favor of it.
Yeah, no, I'm fine with it.
Okay, Jed, and then.
This is a terrific talk. I agree and am chastened by the things that you said. And
nothing I said was about you, Jed. There was like a Jed should have an exception. There's like a little like star, like this doesn't apply to Jed's work, which is
but that alleviates my conscience.
Yeah, you can go to the hot tub now.
I have one substantive question, and I'm following up on the call for peer review. The substantive question is, I was a little struck by how you didn't situate A.B. Dicey's rule of law in an anti-administrative state context. The political background of A.B. Dicey is, for better and for worse, I mean both, critique of the progressive state. I'm going to try and abstract this question a bit, but if anyone wants to know the background, it's on SSRN. What do we do in terms of a world without peer review with law reviews when scholars misuse historical documents, get it through the process of cynically use site checking as a facade that the historical documents in the sentence or the chopped up sentence they've used is actually the words on the document that was taken out of context. And scholars have done this repeatedly, despite having those miscitations and misquotes being used. What do we do after, and I'm only asking this as a hypothetical, what would be your advice when we spot scholars misusing historical documents after they've been published?
So I don't have a great answer to the second question. I have a better answer to the first question. So I'm writing a book on the rule of law, shockingly. So this is why I know this stuff. Dicey is writing in the 1880s. Right? There is a German administrative state, which is the Bismarckian welfare state. But there's not much of a British-English administrative state at this point. And there is this peculiar animus that he has about French administrative law, but the animus is largely about the creation of a separate court system, rather than the creation of administration per se. It is only in the 10th edition of the Introduction to the Law of the Constitution that Dicey adds an introduction to his introduction that is explicitly anti-administrative. And it's this peculiar kind of dyspeptic old man moment, right? Dicey starts off his career as what you and I would describe as a progressive. He's a member of something called the Jamaica Committee. The Jamaica Committee is a body led by John Stuart Mill that campaigned to bring to justice the governor of Jamaica, Irie, after Irie was responsible for colonial massacres. Dicey is a hardcore rule of law legality guy who really cares about colonial excess at the beginning of his career. And then he gets appointed, it's like the perils of success, he gets appointed as Vinerian chair at Oxford. And then there seems to be this long process of calcification. And then by the time that we get to the 1910s, and it's the beginning, it's not the Beveridge report or anything like that, it's the kind of beginning of pensions, right, in England. You have this sort of dyspeptic introduction that Ivor Jennings picks up on and essentially says this whole rule of law business is nonsense, we should just throw it under the bus. But Jennings is really writing about that introduction. So there is this interesting intellectual history, and I think it's as far as I can tell for Dicey, it's that he forms his views, as we all do, sometime when we're 34, and then we never, along with our music choices, we never change them, right? I don't know about the second question. I don't know about, I think that at least our current system of publication does not have, it's not great at correction or corrigibility. And because of the limited skill set of 2Ls, for the reasons that you just said, it is probably better organized for the production of politically useful, yet historically unfaithful claims than it is for producing work that is historically accurate. Right, so I don't have a correction mechanism, but the problem is really is built into our modality of scholarly production.
Okay, I have 4 people in the queue. It's 4:58. We're supposed to 4:59. We're supposed to end at 5. We're not going to end at 5. I'm going to get to everybody who's currently in the queue, and we will go.
Dude, I'm leaving for the hot tub.
You can ask your questions of Aziz in the hot tub.
I told somebody else that so my colleague Jeff Stone, he used to auction off something to students. And what he would auction was a weekend at his house in Michigan. And apparently the highlight was an evening in the hot tub with Jeff. So for all the good that I've done, I've just inflicted that imagery.
All right, we'll move on to the next question. Ash is next. Thank you.
I'm happy to pass. Folks are tired. I can ask the question at dinner, so I'll be pass that.
All right, Katie's next.
Terrific. Aziz, thank you for a wonderful talk. I was particularly happy and intrigued to hear where you wound up, because I've long questioned why it is that we as legal scholars don't seem to direct the insights of legal realism to ourselves, and I take that to be your point. And I just wanted to ask what role you see for candor in sort of threading the needle of honest legal scholarship, because I think that sort of what I perceive as the worst abuses of this come when we are not transparent about our motives and sort of, I think, for example, of the field of interpretive theory, where there's a lot going on there that's had a lot of priors that simply aren't being serviced. So what role might there be for candor in this project?
I'm absolutely not in the business of suggesting that it is either feasible or desirable to expunge all moral commitments from scholarship. Absolutely. Our choice of topics and the manner in which we pursue them are necessarily influenced by our normative judgments. Moreover, in a world in which it is not just that, in my view, law is instrumentalized toward partisan ends, but that instrumentalization is facilitated by, this goes back to Jed's last question, right? By claims about neutrality, claims about legality, particularly in interpretive theory, right? It's impossible to relate or to engage with those without at least seeming that you're taking a position, right? I think that there's a couple of different strategies, and I confess that I have I follow one of them, and I have a really hard time trying to figure out how to lace the other one, right? And I think it's because, or how to trace my way through the other one, and I think it's because for the second strategy I'll give, I just don't have the necessary disciplinary background, right? So the first strategy is to make clear that a topic is being approached with a given normative prior, right? And I tried to do this when I had my aside about Dobbs. I didn't say Dobbs is objective, the language of Dobbs is objectively this or that. I tried to say, look, I have a particular view here, and this is my view. And I've done that in scholarship. I had the piece with Rebecca Wexler on digital privacy, where we simply say, here is our normative view about Dobbs. Here's what we think about the normative entailments of that decision in the world. You can take or leave those, but then here's our positive analysis of the way that this decision will cascade through the digital world. And then we have a set of proposals, but if you don't agree with our normative prior, which we've tried to be very, very clear about at the beginning, then of course you're not going to agree with I assume you're not going to get to page 70, because it's one of those absurdly long law review articles that's written for the idiot 2 hours, right? Those are the bits that I wrote, not the bits that Rebecca wrote the smart bits. Okay, so Canvas, I think Canvas is a solution. Particularly if you're engaged in institutionalist, reformist, or positivist analysis. The second pathway that I don't think I can take is the Jed Sugarman pathway, which is to employ a freestanding set of disciplinary tools that do have their own internal norms and standards, and that can be called to account on the basis of those norms and standards as a way of testing the truths or untruths, or validity or non-validity of certain kinds of claims. And were I a better empiricist, were I a historian, I would do that, but I'm a lawyer and we don't know how to do anything.
Tara.
I can pass. We go along, and we can talk later.
Having just insulted lawyers, Tara's going to pass. No, I'm kidding.
All right. You sure you want to pass, Tara? I think we can do this.
Okay.
I'll give a short answer.
Yeah. Okay, so I felt like there was a bit of tension in your remarks about the Article 2 appointments process being so partisan that nobody else in the world wants to do it, and you're somewhat passing reference to court reform. So if we think that the Article 2 process as is overly political, and I take it to mean both sides, Democrats and Republicans, are both using the process, and I agree with you just talking about that, that working on some reform efforts in that area. If you're worried about that, then I think making what I gather to be a subtle suggestion that we should reform the Supreme Court through expanding the Supreme Court, or packing the Supreme Court, or taking away jurisdiction, would be enhancing the partisanship.
So I did not mean that implication. I have not publicly come out in favor of any of the pack the court, expand the court proposals, because I think that the appointment process, which is hardwired, is one that is inevitably going to produce certain kinds, I wouldn't call them abuses, I just call it certain kinds of predictable patterns of behavior on both the left and the right. I just think that in a world in which the left and the right are this far apart, and we have this kind of appointment mechanisms, of course we get this. And so the packet of traditional reforms that I think that my friends Ganesh and Daniel, Dan Epps and others propose, leave me a little cold, because I just don't think there's a sense in which I think they're question begging or miss what I perceive as the root of the problem. I think if you look overseas, at the debates about judicial design and reform, and if you look at the empirical literature on judicial independence, there's a far richer discussion about different ways of appointing and cycling through judges, linking the bench to the bar in different ways, that we just don't have because of Article 2. So what I was doing in that brief comment was, I was making a point about, I wanted to make a point about the way in which law professors come under, law professors, even of deep and profound moral commitment, find themselves pulled away from those moral commitments by the economy of prestige in our institutions and in our world. And I wasn't suggesting, I didn't mean to suggest, that the particular proposals, none of which I have publicly, and I mean, not that anyone would give a damn about what I endorsed publicly, just don't claim that. I haven't endorsed any of them. So I agree with your sort of futility type argument, or futility type concern.
Final question from Noah.
Thanks, this was so much fun, and it's fun to see how your reflections on this have evolved. As you know, I love the intellectual history part of it, and I wanted to zoom up and sort of think through a puzzle on the intellectual history.
By the way, do you mean that they've evolved since November?
I would say so, yeah. I think you've emphasized a different part of the project now than you did when Aziz presented a version of a talk about this in a paper at NYU, which I was lucky enough to listen to.
I presented a chunk of the book, but the book it's not that they've evolved, it's that the book is a descriptive exercise in accounting intellectual history. And this
is the cutting edge of it.
That would be super boring to do here. Like, I'm trying to entertain you. It's 5 o'clock, there's basketball and a hot tub. Okay, good, sorry.
No, so the question that I had was just thinking about when anxieties about the rule of law tend to be present. And the intellectual history side of it is to think of arguments not just as sort of statements or propositional interventions, but interventions within debates. And your account of Dicey, I thought, did that really well, saying, look, we have to remember that by the time he's making these arguments about the rule of law, he's actually basically a conservative trying to push back against a certain kind of redistributive project. And then when I think about the rule of law in the Anglo-American tradition, that seems to be a way in which the rule of law anxiety often recurs. So the New Deal is a moment when there's a major rule of law anxiety, precisely in a similar circumstance, right? The worry about the administrative state. But in your talk to us today, you mention a current rule of law anxiety, and yet it doesn't seem to share the same parameters. So maybe when John Eastman is worried about or talking about the rule of law, it's not about redistribution in the same way, and certainly in your clarion call to us as law professors, it's neither really for claiming the rule of law tradition to stave off an overreaching state that's going to confiscate our property, or to sort of breathe life into the rule of law to shore up democracy. And so I just wanted to invite you, I know I'm standing between us and the hot tubs, but maybe to help me think about what you understand as that shift. So the question version is, why do we have anxieties about the rule of law today? And are those anxieties the same as the way in which the rule of law as a term in argument has been used to stave off the administrative state and try to rein it in? Or are they different? And if they're different, does that suggest that actually the meaning of the rule of law as a term is evolving? That the reason we're anxious about the rule of law now actually isn't the same as the reason why Dicey or Roscoe Pound in the 30s, why they were reaching for the rule of law?
I think that recall, the rule of law tradition is a distinctive English language tradition. It is not, I think we talked a little bit at NYU about the fact that there's a French tradition, the État tradition, there's a tradition called the Rechtsstaat tradition that has a completely different vector. And in the English language rule of law tradition, you're absolutely right that there is a certain thread where that particular phrase, in part I think because of Dicey's later turn, right, in the 1910s and teens and tens, where the rule of law is a modality of anti-administrative thought. But that is not the only, or even necessarily I think it's a really important, but it's not necessarily dominant as as a catalyst or as a kind of likely provocation to a discourse about legality and the rule of law. So where Fuller and Hart, who also in a kind of oblique way in concepts of law and in the positivism and the separation of law and morals, is engaged with this debate on the rule of law, right? What they are worried about is pathological legal institutions of the kind that are present in Germany, right? And they are, there's a little bit of this bleed of the Kelsen-Schmidt debate. They're at least somewhat aware of that debate into their work. I think that that's a completely separate set of anxieties to which the idea of the rule of law is responding. Here's another example, final point. Why is there a Xi Jinping thought on the rule of law? Why on and it literally, I mean, it's the ideogram translates into English as rule of law, but it has a slightly different meaning in Mandarin, and the pieces of the ideogram are picking up on Chinese thought from which I don't fully understand from a long time ago, or from the legalist period indeed. But why use the phrase rule of law, right? That is responding to an anxiety on the part of the Chinese Communist Party about what we Chicagoans would facilely call the agency costs of having a central Communist Party that runs a complex, divided, and deeply, deeply roiled country like China. And the rule of law, both the five-part project that he has and the Xi Jinping thought on the rule of law, which is totally fascinating to read, is a response to the worry that the party will lose control of the state. And that is a totally different worry from either Lon Fuller looking at Nuremberg and worrying about legality in Nuremberg. It's a totally different worry from the worry of the New Deal critics looking at the New Deal. And isn't it the virtue, isn't it what makes the rule of law such a pregnant, such a fruitful phrase that tradition can encompass and hold all those different kinds of anxieties?
Beautiful note to end on.